Hello and welcome to COS Indiana Live as we bring you Roundtable. The Roundtable segment is presented here every fourth Monday of the month at 7 p.m. We'll be focusing on education and discussion of the topics and challenges we all face as we use the Constitution to save the Constitution. Join us now as we bring you COS Indiana Roundtable with our MC, John Ackerman.
Welcome to Convention of States Today, Roundtable. I'm your host, John Ackerman. You may notice I used a different title for the show, Convention of States Today. We are changing the name, and that's the new name. It's officially effective January the 1st, but we're implementing it today. Convention of States Today, Roundtable. And this is broadcast number 273 of Convention of States Today. And our topic is the Bill of Rights, Don't You Dare, Part 2. I'm going to bring our communications coordinator, Ken. Bring Ken on.
Hi, John.
There he is, Ken Kashuba. I couldn't come up with I knew your first name, but I know another Ken here in my city, and his name came into mind, and I knew not to say it. Ken, talk to our viewers about this QR code up here in the corner, okay?
Yeah, that little QR code over there, John, is for those people that would like to show support for our show, for our everything that we're doing here. It basically will get you a spot where you can plug in your name and an email address. We're not asking for credit cards. We don't ask for your firstborn's name. We just look for your name and an email address so that we can put you into our subscription list. From there, you can also get onto our platform, which will give you access to a bunch of things which you normally can't get anywhere else. So it's kind of a little bit of a platform to thank you for supporting us. And we have a lot of new things coming up in the new year. We'll get to that as we move forward here in the next couple of weeks. But get started there so you're on our list, and we'll keep you well informed.
Great. Thanks, Ken. And that QR code will remain there in the corner for virtually the whole hour of this broadcast.
Watching the version, you can use it still.
Okay. Thank you, Ken. Well, let's bring the rest of the panel on right now. We've got about 3 or 4 more people to bring on. Our normal host for COS today is Dale. Hi, Dale.
Hi, John. Boy, you're in trouble forgetting Ken's name.
I remembered the first half, Ken.
Yeah, you got that part of it right.
But I don't even see your name. It just says COS Today host.
Yeah, it does. I forgot to put my name. Boy, you got me.
You are Dale Parrish.
You caught me, yeah.
And here comes our friend Debbie Stewart, comes and talks to us a lot whenever we have an issue concerning the Constitution. Hi, Debbie.
Hi.
Good to see you. Glad to have you back for this part 2. And the Convention of States Director, State Director from Missouri, Brett Sturley. Welcome, Brett.
Thanks for having me, John. Appreciate it. Always glad to be with you all.
Glad you could make it. And finally, a great member of our Indiana team, Mr. Gary Harbaugh. Hi, Gary.
Good evening, Patriots. Thanks for having me a part of the panel.
All righty. Well, as I said, our topic tonight is the Bill of Rights, Don't You Dare, and it's part 2. Let me explain the reason for that. Last month, we looked at 7 things that the federal government is forbidden from doing. 7 specific actions that are spelled out in the first 3 amendments to the Constitution. And now we're going to focus on the 4th and 5th amendments. They contain 6 really big things that the federal government dare not do. Starting with the 4th Amendment, and there's a clause in there about unreasonable search and seizure. Brett is going to start us off, and Gary's going to continue the conversation. Brett, what do you have to say to us about the Fourth Amendment?
Well, thanks, John. I appreciate it, and appreciate being on with you all. And we'll start off with the Fourth Amendment, just kind of and just read exactly what it says. It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This is really important, and when we talked last time, we're trying to relate back. The remedies in the Constitution were always there to provide recourse for a grievance that was in the Declaration of Independence. And so, if you think specifically about the Fourth Amendment, this follows the founding principle that's in the preamble, the Declaration of Independence, our founding principle of life, liberty, and the pursuit of happiness. And the phrasing of that was originally life, liberty, and the pursuit of property. And so you can see where that kind of where there's dominion, an individual has dominion over their personal property, just implicit in that founding principle. It also dovetails with one of the amendments we talked about last time, the Third Amendment, dealing with the courting of soldiers, and that is grievance number 14 in the Declaration of Independence. And we talked about that, where British regulars would come to one of the colonists' homes, colonists that they were trying to defeat and impose tyranny on, and basically just tell them, hey, everything in this house, we're going to bed down here for the night. Everything in this house is ours. We'll eat whatever food we want to. We'll take whatever we want. And so that's a specific violation. And these were all violations of British common law that, as British subjects, the colonists enjoyed. And there are also several grievances against King George III and how he used the judicial system to punish the colonists. You can see those in the Declaration of Independence. One of the things that this did is it banned the use of general warrants. And a general warrant is one that's issued to search a residence, but doesn't specify the purpose of the search, the areas to be searched, or specifically what they're after, what law enforcement will be after. In just a couple quick examples, I know Gary has some here as well, but just a couple quick examples. One that affects inner city population a little bit more. It can affect everybody, but it seems a little bit more sensitive. Inner city population is civil asset forfeiture. And that would be to where maybe a search warrant is issued for a drug violation, but when law enforcement comes in to that residence, they see other evidence of potential crimes, maybe a firearm that is not specified in the warrant that's related to the crime that they're there to investigate, but they'll see that property, maybe seize other property. And that goes down to the jail, into the evidence locker. And even if it's not connected to the reason why law enforcement is there to begin with, and then if it's proven not to be connected, then the individual that has that property seized then has to pay and go through the court time and the court costs and pay to recover their property that was improperly seized. And in a lot of instances, they simply don't have the resources to do that, and so they have had their property improperly seized, and that's a violation of the Fourth Amendment. And then just real quickly, a recent example of this is the August 9th, 2023 raid of President Trump's Mar-a-Lago residence. That could be considered a general warrant. I consider it a general warrant. The arguments are made on both sides. It definitely, if it's not a general warrant, it definitely steps right up to the line, and to where they basically just went through every single part of his home, and they knew this was supposedly to retrieve some government records. They knew where these government records were, but yet they went through all different areas of the Mar-a-Lago residence And it was just humiliating. But I would say that would be a general warrant. So I know.
Yeah, I remember when that happened. It seemed to me that sounds like a general warrant, which is forbidden. Government is not allowed to do that.
Correct. Yet they did it anyway. Yeah.
Go figure. Okay, Brett, are you ready for Gary to share some?
All yours, Gary.
Go for it.
Thanks. I was going to mention just a couple of other areas. This is an ongoing area of litigation and, what is going on. So one of the things that the Fourth Amendment requires is, them to identify specifically what they're searching for. Well, what's happening today, government may seize your cell phone. Guess what? This is like having a general warrant because they've got your contacts, your emails, your text messages, your phone calls, your photographs, all kinds of things. This has not been a discussion in convention of states about putting an addition to the Fourth Amendment, but maybe it's something we should be thinking about, because when electronic devices are seized, it becomes in effect a general warrant, and there's no limit to what they can look at on that electronic device. So this, to me, is something it needs to be addressed, and the court's not likely to really want to address it in a way that protects the rights of the people. Another thing there's ongoing litigation in, I think, 5 different states concerning something called the open fields doctrine. And this is a doctrine from hundreds of years ago that basically said if the sheriff is driving or walking by your property or riding horseback by your property and he sees something out there in the open field, that it's not subject to this restriction on getting a warrant. And what's happened today is with electronic surveillance, binoculars, drones, all these kinds of things, this open fields doctrine, and where it really applies most often in most states, and I think Indiana as well, the Department of Natural Resources, the guys who go out and look for fishing violations and things like that, they basically are given a general warrant. They can go anywhere on private property. And that's why this is subject to litigation, because they're saying, hey, wait a minute, the Fourth Amendment says you can't do that. And I think this is an area that, again, is, it's alive and well today, and it's not something that's old and dusty and not going to go away.
Yeah. The government is not allowed to conduct unreasonable searches and seizures. Not allowed to do that. That's one of the things that's forbidden. By the way, if you're watching live on Facebook or YouTube and you have a comment or question at any point during this broadcast, just type it in there, and Ken Kashuba, I know his full name, Ken Kashuba is monitoring those, and as appropriate, he'll bring up some of your comments and questions. Ken, do you have anything so far on this Fourth Amendment? Maybe not, but maybe.
Just an agreement there that, of course, they would leak any info they like, is what David says.
And we get to see who David is, I think. Either that or it's an avatar. I don't know, David. Okay, thank you, David. Thank you for that. Well, let's move on to the Fifth Amendment. This is a big one. It's going to take up the rest of this hour, really, because there's a lot of specifics in there. And the first thing I'm going to ask Brett to talk about is that very first clause of the Fifth Amendment that has to do with proper indictments. Brett?
Forgot I muted myself. Apologies. Thank you. I just briefly, I know we're going to cover all this because there is a lot of territory, but just to briefly read what the Fifth Amendment states is no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. That might be like the world record run-on sentence right there, but there's a lot of territory because this is extremely important. So, just in the area of indictment, And I think what an indictment is, it's a formal charge of an individual or other entity, like maybe a company or a club or organization, of an alleged criminal offense. And this is a constitutional guarantee that an individual or other entity knows exactly what crimes are being charged with. And I want to refer to Rule 7 of the Federal Rules of Criminal Procedure, because it provides a list of the minimum information that indictment has to contain. And this is from what I've seen, at least anyway. I'm no lawyer, but from what I've seen and studied, seems to be pretty common among the states. So those four things are plain, concise, and definite written statement of the essential facts constituting the offense charged. The suspect's identity, unless the suspect identity is unknown. Citation of the statute or regulation that was allegedly violated, and a signature from a government attorney. So those are the four areas that the Federal Rules of Criminal Procedure say has to be an indictment. And a good example of it seems like when we're talking about this due process violations, it can always be linked back to something that's been done against President Trump in the last 8 years, and this is no different. So, this was one thing that was not followed in the New York. They call it the hush money trial. It's not hush money. There's a non-disclosure agreement, which is 100% completely legal. But this was not filed in that the non-disclosure agreement trial of President Trump versus E. Jean Carroll. The allegation was made that President Trump had misclassified a payment to Carroll under a non-disclosure agreement. And that agreement was made and said, here, I'm going to pay you this much money just to keep quiet about this story, whether it is alleged actual behavior, alleged behavior, whatever. A lot of times, whenever more wealthy people are charged with some type of allegation, or somebody threatens to go public with something, they'll say, look, there's nothing to this, but you know what? It's going to cost me $1 million to litigate it. It's going to cost me $200,000 to pay this person to just shut up and go away. So I'll be money ahead and energy ahead, just pay the $200,000, even though I did not do anything wrong. So what the prosecution argued, that this non-disclosure payment was a campaign contribution, because it was going to be something that would help enable President Trump to be elected. So this was a misdemeanor violation that had the underlying state statute had a statute of limitations had expired, but the New York legislature opened a 1-year window to allow sexual assault cases to be filed. This window just coincidentally happened to coincide with the 2024 presidential election season. I'm sure that was just an accident. But the prosecutor, Alvin Bragg in this case, had elevated this to a felony, which brought it into federal court. And by stating that it was a federal campaign law violation, even though this had already been investigated fully by the FEC, the Federal Election Commission, they passed on it, said there's no violation here, even though the previous New York prosecutor in the Southern District, Cyrus Vance, had looked at this and said no law had been violated here. Alvin Bragg obviously, campaigned on, I'm going to get President Trump, so elect me. Well, he was elected, and so then he filed this case. But Alvin Bragg never ever specified the underlying federal statute that was allegedly violated that brought this to a felony. And so this again is a violation of this indictment clause. And I would argue, just like with the unreasonable searches and seizures, unfortunately, this will continue to happen in our lawfare environment until these prosecutors that violate our constitutional rights are disbarred, face penalty, or thrown in jail. And that's really what needs to happen in order to get this stopped. So, but that's maybe not so briefly the indictment section of the Fifth Amendment.
Well, that's pretty important stuff. Thanks, Brett. And to refresh your memory, That Fifth Amendment says no person shall be held to answer for a crime unless on presentment of an indictment. And as Brett read, the federal rules of prosecution specify what must be in that indictment. And you can see several violations of the Fifth Amendment. If you just look around, it's happening. And Convention of States calls for reining in the scope and reach of the federal government. And this is one abuse that just really has to stop. So let's move on to the second clause. And Debbie's going to talk about that second clause, which prohibits double jeopardy. And what it says is no person shall be subject for the same offense to be put twice in jeopardy of life or limb. Okay, Debbie?
Yeah. Okay. So you can only be tried once. Okay. And just a little history. Back in England, before the colonists came over, a defendant at a trial could plead a former conviction or former acquittal as a special plea in bar to defeat the prosecution. So that kind of, when we came to the U.S., it worked its way into several of our states' Bill of Rights, and following the American Revolution. And then there were some differing approaches, but the Senate approved it and the House accepted it. And they presented our modern day language that we have now in the Fifth Amendment. So it's really only supposed to happen in criminal proceedings for this double jeopardy. It prohibits anyone from being prosecuted twice for substantially the same crime. And this clause provides 4 essential protections. Like the first one would be a second prosecution after acquittal. A second prosecution after conviction would be number 2. Number 3, multiple punishments, or number 4, multiple prosecutions for some offense by different sovereigns. And there is an exception the Supreme Court has made that you can be tried by both the state and the federal government if it falls within both of those. Okay, so that's the exception. So that's kind of how double jeopardy works, which is really a great protection for us. Because if the government could keep taking you to trial, they're eventually going to get a guilty verdict, aren't they? So they could just keep going back and back and back. So an example of this, of the government not following this or slightly not following this, is actually United States versus Georgia, Damian McElrath. And the case was that this Damian man murdered his mother, and he had 3 crimes against him: malice murder, felony murder, and aggravated assault. But the problem was the jury delivered a split verdict. So on one hand, they said, well, he's not guilty by reason of insanity for malice murder, but he's guilty but mentally ill on the other 2 counts, on the other 2 charges. Well, the Georgia Supreme Court basically said this is repugnant. This is inconsistent mental state findings. And they vacated both of those verdicts and ordered a retrial. And then they appealed. And then the United States Supreme Court said they held in Damian's favor, saying he's not guilty by reason of insanity. And that verdict was as an acquittal. So he gets to use the double jeopardy here. And so he's not guilty, or he doesn't have to, he gets to use the double jeopardy clause, is what I'm trying to say. So there was no retrial in that area. So these are these are like little loopholes here and there that, depending on the lawyers and how things go, that it applied to him. So I don't know whether that's really the right way of doing that, but it seemed a little bit shaky to me.
Okay. Thank you, Debbie.
Yep.
This is an important constitutional protection. You, our listening friend, cannot be put in jeopardy twice for the same accusation. If you are, it's a violation of your Fifth Amendment, and it's perfect grounds for appeal. So, period, full stop. That's just the way it is. Well, we're going to take a short break now and introduce to you a brand new video series that I'm working on. It's called Teaching Truth to Tamara. And we're going to show you episode number 1 of this. And you're going to find out who this Tamara is, Tamara Scott. I'm going to tell you who she is and why we need to teach some truth to her. So here comes episode 1, Teaching Truth to Tamara. John Ackerman for Convention of States, Indiana. Welcome to my brand new series, Teaching Truth to Tamara. Who, you may ask, is Tamara? And so this episode, number 1, is entitled, Who is Tamara Scott? Well, she's a conservative Iowa Republican. In fact, she's the state of Iowa's Republican National Committee woman. She serves as the Iowa State Director for an organization known as Concerned Women for America, which claims to be the nation's largest public policy women's organization. And she lobbies for pro-life, pro-family legislation in the Iowa State House. According to her website, she is committed to raising up tomorrow's leaders. She understands caring for her 4 children is the greatest role she can and will ever hold as she helps to shape our country's future. Her website continues that she was appointed to the United States Commission on Civil Rights State Advisory Committee for Iowa. She has served on numerous boards and government committees and has volunteered time to many campaigns, referendums, and ballot issues. In 2007, Tamara was named one of America's top 10 most influential kingmakers by the Religion News Association. In 2010, she began hosting a cable access television show called Truth for Our Time, helping viewers live God's Word in today's world when the headlines hit home. Tamara has hosted radio and cable TV programs since 1998. She hosts a weekly online show called Tamara Scott Live. She's interviewed on national television and speaks at conventions and conferences. Now get this, Tamara served on the 2024 Republican National Convention Platform Committee. And the list goes on and on. She's quite an impressive leader and is right about so many things. However, you knew there had to be a however, right? Tamara Scott is an avid opponent of using Article 5 of the United States Constitution to call a convention of states to propose amendments to the Constitution. That's her prerogative. She can do that. She can be opposed to it. But she's dead wrong about it. Here's one example of how wrong she actually is. Tamara accuses Convention of States leadership, including the renowned constitutionalist Michael Farris, of working with globalists to shred our Constitution and destroy American sovereignty. She states that Michael Farris wants our Constitution to be upended and replaced. And she's actually serious with these accusations. She claims, and I quote, "They don't want to just change it. They want to replace it, rewrite it," referring to the Constitution. Well, for your information, that's a thumbnail sketch of who Tamara Scott is. In future episodes of this series, I'm going to play some clips from her internet show and expose just how wrong she is about Convention of States. I'm going to be teaching truth to Tamara. Well, there you have it. And I'm having fun. Ken is helping me get these clips and getting these episodes recorded. And we're going to be bringing those to you probably weekly in the Convention of States today. Uh, Dale, you got a name now. Look at that. All
Yes.
right. We took a
John,
break and
by the way, I'm sorry on that video. I'm just going to flash this up. I missed the intro to that video.
you
And
did.
I just want to show that real quick.
Okay.
There it is.
Oops.
I just
Okay,
wanted
we had
to
the Superman.
get the Superman in there. Sorry,
Yes.
I missed that on the first time. So
Superman teacher, and Ken created all that, and he's putting the clips together for us. And so, thank you, Ken, for helping me with that. Well, let's come back to the Bill of Rights. Don't you dare, Part 2. We've looked at the first two clauses of the Fifth Amendment, and I'm going to ask Gary to talk about the third clause, which says no person shall be compelled in any criminal case to be a witness against himself. Gary?
Thanks, John. So one of the things that could happen, used to happen, was they could put an accused on the stand and force them to testify in a trial, which of course would subject them to cross-examination by the prosecution and all sorts of things. It's easy to twist people up during an interrogation of this type. So that was one of the things they wanted to protect against. And Supreme Court has gone further in saying that you can't even be questioned when you're arrested if you choose not to talk to the police, which is something that I would advise anybody to do because it can't help you. And truthfully, people who are innocent are often caught up in thinking, well, I'm innocent, so it doesn't matter. I can talk to the police, and they can take what you say and twist it. And they may misremember what you told them. All kinds of things can happen when you talk to the police. And so part of this, if anybody's ever watched a police procedural, you know, the Miranda warning from the Miranda versus Arizona case, Supreme Court said, hey, you got to tell the defendant at the time of the arrest that they don't have to answer any questions, and anything they say will be used against them or can be used against them in a court of law. And so this is partly justifying, but this also ties.
Yep, I think we're losing him there.
Yeah, he froze up on my screen. I don't know if he froze up on everyone else's screen, but I guess so. I guess we lost Gary. Maybe Gary needs to leave the room and come back in.
Am I back?
There you
you're
are.
back. Hi, Gary. Good.
I'm back. Thank you. Don't know what happened, but anyway. So it's not only that a person can't be compelled to be a witness in a trial when they're a defendant. You can voluntarily waive that right and testify, but they cannot force you to do so. They cannot force you to answer questions at the time you're arrested. And they cannot, this ties in with the Fourth Amendment, they cannot just go in and seize papers, documents, evidence from you that you have not consented to unless they have a search warrant or you've given consent. It's the idea of being able to protect people against incriminating themselves. And the Supreme Court, and I think the framers of our Constitution probably understood that there would be guilty people who would go free because of this. But what they recognized is that criminal proceedings provide enormous opportunity for the abuse of government power. And haven't we seen some of that? And that's why they wrote these protections into the Bill of Rights to say the people should be protected from the large power of government. Government has basically a blank check to go after people in terms of finances. Most people don't have the money to defend themselves against a serious criminal charge. And so they wanted to kind of level the playing field to give people some additional rights. And one of those important ones is that right against self-incrimination and the right to be protected from an unreasonable search that ties in with it.
Okay, Ken, what do you have?
We have a question, I think, which we could probably direct towards our lawyer on the panel, Gary. I'll go ahead and post this question up here that comes from David. He wants to know is a confession, if used in court, testimony against oneself?
it is testimony against oneself. And the question always comes up in this situation as to whether or not it was voluntarily given. And so, um, sometimes they'll bring somebody in and they agree to talk because they think, hey, I can outsmart the police if they're guilty, or they think I'm innocent. And they might arrest you at 5 o'clock in the afternoon and still be questioning you at 5 o'clock the next morning. So this is an abusive type practice. And many times people who aren't too smart, the police say, look, if you just go ahead and confess, the court will go easy on you because you confessed, right? And tens of thousands of times people have confessed to things that they didn't do, particularly people who are mentally not as sharp. And they might confess to something thinking, oh, this is going to get me out of here and I can go to bed and I can get something to eat. And they wind up using it against them in court because they allegedly voluntarily gave such a confession.
I think David kind of alluded to that right afterwards, because he posted after that. I guess that's voluntary testimony. So
Voluntary, yeah.
Does it matter if do they have to be Mirandized first, Gary?
They absolutely have to be Mirandized. Now, sometimes when somebody is arrested, they will immediately blurt out some kind of a confession. And these kind of cases, typically the courts have said, no, you have to warn them before you can use that confession. It kind of depends on the circumstances of a particular case. But, if the guy calls 911 and says, I just shot my wife, they're probably going to use that. It's not technically a confession, but it's a statement like that. But there are other cases where the courts have said, hey, you questioned this guy and all of a sudden, they forgot to give the Miranda warning and the guy said something, and the court is much more likely to say, we're not going to permit that confession. These really come down to depending on exactly the facts and circumstances of each particular case and how it lines up with, prior case law and so forth.
Interesting.
I saw something about 23, 24 years ago that just blew my mind. It was a local case, not a federal case, but still, Fifth Amendment is going to apply here in this story. She was a coworker of mine, and she had murdered her husband. And when the sheriff arrested her and took her in for interrogation, and they played the interrogation video during the trial, which I attended because I knew the defendant. The sheriff explained, he read her Miranda rights to her, and she said, yeah, I'll voluntarily answer your questions. And he handed her a paper, and she signed away her Miranda rights. And in that interview or interrogation, she told the story of how she killed her husband. And guess what? The prosecution played that. It was a voluntary confession, and she should not have done that. She should not have talked. She should have said, I request an attorney. And I know from watching television, which makes you an expert, that that if you request an attorney, interview's over. Because once you pull that trigger, at least the popular understanding is that they're not going to go any farther with the interrogation because they know they're not going to get, and you don't have to say anything. You can just sit there in silence. You do not have to talk. Yeah. So, and my wife and I like to watch these true crime stories where they show these things. And we've said to each other over and over again, never answer questions in a police interrogation room. Always request an attorney, even if you're innocent, because they can make it. Like Gary said before he disappeared into cyberspace, they can twist your words around and make it look like you're guilty. And many a person has been falsely convicted. Yeah, based on that. So, fortunately, Gary was done talking about that. So I want to move on to the next clause of the Fifth Amendment, and which says the one and only Dale Parrish is going to talk about due process.
Yeah, I just got a message from Gary. Evidently, his internet totally crashed. So that's why he disappeared. Okay, the Fifth Amendment. of the Constitution establishes fundamental principle of due process of law. Well, this protects individuals from being deprived of life, liberty, and property without proper legal procedures. And there's three aspects to due process that I want to stress here. Number one, meaningful due process. Now, this refers to the protection of certain fundamental rights from government interference. Even if legal procedures are followed, it ensures that laws and actions by the government do not unfairly infringe on individual liberties. The second instance, the second aspect here is called procedural due process. Now, this aspect ensures that legal proceedings are conducted fairly and with transparency. Now, pay close attention to these. These are good. These are good, okay? Such rights as notification of charges or legal actions, okay? Second, the opportunity to be heard. In other words, presenting a defense or evidence in court. And the third aspect is a neutral and impartial decision maker. Now, that's an important one. That's an important one. I'll be coming back to that one here pretty soon. So that's the first and second aspect. The third aspect is application to federal actions. The Fifth Amendment's due process clause applies to the federal government in that ensuring fairness and the rule of law in federal actions. And certainly, of course, states are bound by similar provisions of the 14th Amendment. So that's basically the due process part of the Fifth Amendment. Now, got a couple examples I want to talk to you about. The first example, and these are examples of abuses, okay, of the due process clause. And this first example goes back in history before my time. Now, it might have been, John, you may remember this, but it's before my time. I'm just kidding. No, this is before I know John's age. This is before our time as well. But right after Japan attacked Pearl Harbor, right after December Pearl Harbor in 1942, if you recall history, the government gathered up all Japanese individuals, Japanese, any persons of Japanese descent, be it citizens or our immigrants, to the tune of about 120,000 people were all gathered up, no court, no legal proceedings, no due process, and all of them shipped to an internment facility that had been constructed. That actually happened. That actually happened in our country, and you can imagine, you can kind of understand. Right after Pearl Harbor, emotions were very high in World War II. So, but that did happen, and that was a misuse of the due process part of the Fifth Amendment. The second example that I want to talk to you about is something that we have been featuring on COS Indiana Today for some time now, and that's the January 6th incident that's going on. And I'm telling you, I have I've interviewed some J6 prisoners. I've interviewed people involved in the network that has formed out there to support these J6 prisoners and their families. And folks, I'm telling you, there are examples after examples of due process not being afforded to these individuals. I had one prisoner now a prisoner now, been in prison for over a year and yet to be tried. We've had a couple out of Texas that were tried, and their sentencing was delayed 5 months. Every month was supposed to be started in, I think it was May of this year, and every month it got delayed. It got delayed the next month and next month. So they waited 5 months. Now, this whole time, they've been on home confinement. So, it's like one of the prisoners told me that the punishment here is really the process that these people have had to go through and that are still going through. And of course, one of Trump's day one promises is to pardon these individuals or pardon many of them. So we're definitely have our eyes focused on that process. But here, that is a current example, and I'm sure there are many others that we could think of, but that's a current example of how our government is not handling due process properly according to the Fifth Amendment. So,
okay, that's important stuff. Thanks, Dale.
Mm-hmm.
All right. Well, let's move on to the final clause of the Fifth Amendment that says, "Nor shall private property be taken for public use without just compensation." And for this, we come back to Debbie Stewart.
Okay, so this is often referred to as the takings clause. And if there is to be, like, let's say the government wants to take your property, two things must be true. First of all, the property has to be put to public use. And second of all, they have to pay you just or fair compensation, a fair price for your home or your property or both or whatever it is, whether they want part of it or all of it. So those two things have to happen. Now, history tells us that this actually started in Section 38 of the Magna Carta and eventually became a protection of lands in England. And John Locke, Sir William Blackstone, and Sir Edward Coke all believed that property rights were part of our natural rights. And so that was kind of the feeling in England at that time. So when we came over here to America, it influenced a lot of our English authors that came this way, and it made its way into the Declaration of Independence. And then, of course, Jefferson was an anti-federalist, so he felt like, well, I don't want the government to be too powerful. So he advocated that this get put in the Bill of Rights, which is why we're talking about it today. It's in the Fifth Amendment. So before I give you my example of government abuse around this, there was one case. It was called the Kelo case. It was in 2005. So remember, I said one of the two things was it has to be used for public use. They started bending it to be used for public benefit, which opened up the whole quagmire of so many other things they could take your property for. And so there was a whole movement in the country and other places like, you can't take my home. And people got behind this as protesters and organizing around, the government can't take our property because these are our rights. So that case, the Kelo case, it was Kelo versus City of New London, really spurred on this, hey, the government can't do this. How are they doing this? So it was like the worst, least popular decision in 100 years by the Supreme Court. But now just today, the Supreme Court Justices Gorsuch and Sotomayor today, the 25th, have called for review of the takings clause after the Supreme Court declined to hear a case of a woman in Texas. Her name was Vicki Baker. And what happened was, this happened in 2020, but today was the day that they're talking about they might review it, but they turned it down. But there was a police standoff at her home, and they used tear gas, explosives, a vehicle, all this stuff happened. Her dog, is blind and deaf now, $50,000 in damage. There was a fugitive who was holding a teenager hostage. And so you can imagine all the things that went into her home. So basically $50,000 in damage. The insurance refused to pay. The city denied any just compensation. So she filed a lawsuit, and the district court ruled in her favor. But then the circuit court overturned it, saying the police actions during emergencies are exempt. So they called this an emergency. So they're not willing to give her any money. She basically, everything in her house was destroyed. The tear gas destroyed things. They had to bring the hazmat group in. And so the way it is right now, they're saying, no, she's not going to get any just compensation. But those two Supreme Court justices, Sotomayor and Gorsuch, said that they wanted to go back and they may revisit it at some point in time. And they left the question of, are there exceptions to the takings clause? They're saying that it wasn't public use, it was public safety, so she doesn't get just compensation. I know, right? So, I mean, I understand what they're saying, but still, that the police is part of the government, right? We pay our taxes for that, and they completely. So that's
wow. That's incredible. Okay. I take it that you're finished, Debbie.
Yes, sir. Thank you.
All right. Well, we didn't quite take a full hour, but don't worry, next month we will, and I'll tell you about that in just a second. This brings us to the end of this month's Convention of States Today Roundtable. Before we close it out, I want to give you our email address. If you have any questions about Convention of States, you can email them to us at raiseyourvoicecos@gmail.com. There it is on the screen, raiseyourvoicecos@gmail.com. And I want to invite you to tune in next Monday, December the 2nd at 7 p.m. Eastern for our next Convention of States Today, where we're going to have part one of the January 6th Pardon Project. We're going to have an episode of Meet the Founders and a COS Basics and a Truth for Tamara is what it says there. So that's next Monday at 7 p.m., December the 2nd. And our next Convention of States Today Roundtable will be on the fourth Monday of December. And that will be December 23rd. And we're going to take up part 3 of Bill of Rights, Don't You Dare. Now, it might take more than an hour because we intend to cover amendments 6 through 10. And there are a lot of important things in there, but we're feeling the need to wrap this up and finish up. It turned into a 3-part series. We don't want it to become 4 parts, but we want it to become a 3-part series on the Bill of Rights, Don't You Dare. And here's a little joke to help you remember. It's going to be on Christmas Adam. It's the night before Christmas Eve, and I like to call it Christmas Adam because Adam came before Eve. And so because of that and proximity to the holiday, we're going to pre-record the Bill of Rights, Don't You Dare, Part 3. And so what you'll be watching is a world premiere of the recording that the same 6 of us are going to do in a couple of weeks. And we'll show it to you at 7 p.m. on Christmas Adam, December 23rd of 2024. And now to close us out, here's an episode of the series on COS Basics. Oh, wait a minute. I wanted to tell you this. If you go to that web address, conventionofstates.com/Trump, there's an open letter there to President-elect Trump. I read it, I signed it, and you can sign it too if you go to that web address. It's encouraging, asking President Trump to endorse the Convention of States project. Many high-level government officials have already endorsed it. He stands in favor of a lot of what we stand in favor of. And we want to encourage you to go to our website, conventionofstates.com/Trump, and read that open letter and sign it if you so choose. Okay, now to close us out, here's an episode of Convention of States Basics on good amendments. John Ackerman for Convention of States, Indiana. In this episode of COS Basics, I'm indebted to attorney Rita M. Peters for these ideas. She tells us that beneath the cloud of dust that's been raised by those who oppose an Article 5 convention, there are real answers to be found to genuine questions or concerns about the process. And here's the first one. Good constitutional amendments can correct most of the abuses of federal power. Let that one sink in. Good constitutional amendments can correct most of the abuses of federal power. First of all, it's important to understand why Convention of States is seeking an amendments convention in the first place. Adding amendments to the Constitution is a serious and difficult business, and we would not undertake this enormous effort if we believed that there were some other way to put our nation back on its proper course. Most of the problems we now face as a nation are the result of erroneous interpretations of the Constitution that capitalize on ambiguities in the wording of certain phrases. For example, the General Welfare Clause is now interpreted as unlimited power to spend money. So we can restore the federal government to its proper, limited place only by clarifying the original meaning of those phrases through constitutional amendments, effectively overturning the bad Supreme Court precedents that have eviscerated our federal system. So, I close by repeating Rita Peters' point. Good constitutional amendments can correct most of the federal abuses of power.